Good morning, everyone. So in the first quarter of this still relevantly new year, we had a number of events and reviews discussing tendencies and transactions and M&A across the Baltics. But usually in those types of events and reviews, merger control procedures are a minor part of discussion or even a missing part of discussion. However, given that merger control rules and procedures may have a significant impact on your transaction, time and cost-wise, even possibility-wise, one shall not assume that merger notification is just a formality necessary to close the deal. Thus, today we have our TGS Baltic competition team from all 3 Baltic countries. And our team deals with both national competition authorities and cooperate together in mergers across the Baltics. We also have our guest speaker, Mindaugas Cerpickis, managing economist from Copenhagen Economics. And all of them today will share their insights, experience, and views on relevant tendencies in merger control procedures. Today we'll have 3 presentations from TGS Baltic lawyers and also introductory statement from Mindaugas. And after that, we'll have a discussion. And you are also all very welcome to write your questions. There is a chat box next to the translation. So feel free to have your question, and we will do our best to address that to a relevant speaker. So without a delay, I would like to ask my Estonian colleague, Anne, to start this event. And Mari today will talk and remind us that transactions which fall in the scope of merger control, not only those which are more conventional, such as buying a company, but also asset deals. So Marianne, the floor is yours.
Thank you, Rita. Good morning, everyone. I'm going to share my screen. And there we go. So as Rita said, my name is Marianne, and my goal for this morning is to share some relevant market practice with respect to transactions that are aimed at transferring not company shares, but rather operating assets or parts of companies. So, okay, and we already have technical difficulties because I can't change my slides. One moment, please. Okay, so as it happens, the first presenter always has to counter with the first difficulties. So again, the reason for selecting this topic is that in the course of our work, we see that sometimes it is difficult to spot whether a transaction may indeed constitute a merger within the strict sense of the competition law rules. But this understanding is, however, crucial, as on this other mandatory regulatory requirements depend. For example, the obligation to notify the merger or notify the transaction for the competition authority, the relevant competition authority of the relevant jurisdiction or either an European Commission. So under the competition law rules, a merger is, inter alia, the acquisition of at least one undertaking by purchase of assets, by contract, or by any other means. And if the transaction volume exceeds a mandatory threshold, the transaction must be notified to the competition authority for emergence clearance. Even though the competition law rules are harmonized all over across the European Union and are actually similar in other jurisdictions as well, the thresholds for notifying the deal are different. So this is the first thing that should be kept in mind when entering into a transaction. So, for example, in Estonia, and in other countries too, we have to analyze both the aggregate turnover and of each parties and the separate turnover as well. So failure to, I can't believe it. Okay, so why the failure to notify the asset deal will be fined. So there are quite severe consequences in case the deal is not properly analyzed. And again, the fine amounts may differ per jurisdiction. And our maybe the main thought that we would like to give to you from this seminar is that the transactions must be analyzed not only from the volume perspective, but also from the purpose of the deal as well. So the purpose of the deal is quite crucial here, and it must be understood for the both parties what are their actual intentions to acquiring either the part of assets or the whole like business operating unit. Because sometimes, and it is actually quite common, that the actual intentions may lead to the interpretation that the party's actual purpose was to agree on either sharing of market or agreeing on exiting of market of one party. So this could be interpreted also as an anti-competitive agreement, which are prohibited. So this risk also remains before when the agreements or the purchase or transfer agreements of the assets are not analyzed properly. So what is an asset deal anyway? In case of a so-called share deal, it's quite easy to understand because the shares of a company are transferred to the buyer. However, in the case of an asset deal, only certain or possibly all assets are acquired from the target company. So they can be like selected assets or all operating assets. And it can be, as I said, it can be the whole operating unit or a part of it. So the examples start from real estate, machinery, laboratory equipment, different inventory, digital assets, IP. So for example, if the company's main asset is basically their employees or the IP that the employees create, so even like the small or the transfer of a team may also in some cases constitute a transfer or a merger that could be notified to the competition authority. So in my following presentation, we will now go over of some of more interesting cases from the Estonian competition authority practice. Nevertheless, even though we are going to explore primarily the Estonian competition authorities cases, since, as I said before, since the competition law rules are quite similar in different European countries, then the findings that we are going to explore now are probably applicable to other jurisdictions as well. So the first example is agricultural land. The example derives from the decision of the competition authority concerning also a big bank who was part of a deal, and here the competition authority also approved the merger, and the merger had to be notified because the agricultural land, since it probably generates like business and turnover, and is important for commercial activities, at least for certain companies like agricultural companies, then agricultural land constitutes a separate asset, and this this transaction should be notified as a takeover of part of an undertaking. And of course, there is a of course, I just told you that the rules are similar across different countries, but there is still a special point of attention in Estonia, because at least in Estonia, asset deals with no turnover must also be notified under some circumstances. And this is due to the rules of calculating the turnover of an undertaking set out in the Competition Act. So sometimes sometimes it happens to be that the turnover of previous 2 years must also be included in the party's turnover, and this calculation may lead into the exceeding of the thresholds set out in the competition law. So similarly to agricultural land, buying a separate building which allows its operator to rent office spaces is probably also an asset deal which needs to be notified. So one of the biggest or the easiest examples here in Tallinn is the acquisition of Danske Bank building in Tallinn city center. As we all know, Danske was forced to quit its operations in Estonia, and therefore also had to get rid of its offices here in Estonia as well. So the purchase of the main building in Tallinn had also been notified to the competition authority as a transaction concerning the market of renting of office spaces here in Tallinn. Similar to the previous example, we have different examples of acquisition of parts of undertaking, like showrooms and maybe hotels or other buildings that belong into one group and can be and constitute like separate undertaking active in a separate sector. So, for example, in this decision concerning Top Auto and Autobahn in Estonia, the transfer agreement was made between the parties with an object of acquisition of a showroom. And so the same showroom was part of an undertaking active in retail sale and servicing of Citroën branded vehicles. So, and the same rule that the separate undertaking or the separate bundle of assets has to be notified can be applied also to other similar sectors. Like, for example, I have a picture of a hotel here. So if one hotel chain decides to get rid of one of its buildings, then it's probably an asset deal. So that needs to be notified. So maybe other thing or other type of examples that come sometimes as a surprise for companies is the transaction of concerning of intellectual property that typically also need to be notified to the competition authority if the threshold volumes are exceeded. So, for example, in this decision concerning Postimees and Telia, the sale purchase agreement of assets was concluded, and the assets were consisting of Netibook, the search engine, hardware, software, domain, and trademark, all supporting the search engine. And so these assets altogether represented a part of the undertaking because they were like separately business operating assets. And thus the deal had to receive a clearance from the competition authority. And another example is of ad portal and domain and the trademark of a newspaper portal. So these are two separate decisions concerning the same group. And the first example is concerning the acquiring of control of SOV advertising website, and the other one is acquisition of assets of the limited liability company of OÜ Põlva Koit, and the whole assets actually consisted of only a trademark and domain. But still the transaction needed competition authority approval. So I think we have gone over the both smaller and bigger cases in the competition authorities practice. And asset deals, they can be, of course, both, like they can be simple or they can be very complicated. Maybe one of the simplest, or at least one of my favorite example, is the acquisition of a registered short number. It's one of the earliest decisions of the competition authority concerning Confido, when one of the merger parties operated a general practitioner remote consultation services, and the other one operated with a consultation line concerning pediatric consultations. And so the competition authority firstly saw there a possible horizontal overlap in the remote consultation, since the operating this registered short number constitutes provision a separate service on the separate market, and therefore the deal was again had to be notified to the competition authority. But one of the maybe very difficult cases that was a part of multiple clearances and multiple notifications on the community level from the European Commission was the Airways acquisition of E.ON electricity generation assets. And the deal was very complicated because it was a part of a major asset swap. And the part of this asset swap deal was acquisition of majority of E.ON's renewable and nuclear generation assets, and a small percentage minority interest in E.ON as a part of payment for the assets. So the European Commission had to assess the impact on the generation and wholesale supply of electricity. So this is this deal already is from a couple of years ago, but is still concerned like one of the biggest deals at least in German history. Maybe coming back to or in the beginning of my presentation. So when I was trying to introduce the purpose of today's or my presentation. So why are we here? As mentioned, asset deals may also slightly turn into cartels because sometimes, and especially in cases where they are not notified because the thresholds are not exceeded, and therefore maybe if the thresholds are not exceeded, then the parties are not that eager to start analyzing the actual intentions behind it or actual purpose of the deals. Such deals may also have a collusive outcome and lead to market allocation, can result in that unaffiliated competitors may be left at significant competitive disadvantage. And they can also constitute other restrictive effects on the competition. So, for example, in the case of Tartu Mill in Estonian, that was also weighed by Estonian courts, the sell purchase agreement was concluded between the parties, and one party, Tartu Mill, they bought a mill, a car park, and the laboratory equipment connected with the mill. However, the seller or the owner of the mill was not that eager to enable the actual use of the bought assets. It was not possible for the purchaser to dismantle the mill and actually use the purchased assets. So this deal went to court, and where among other things, the court had to assess the actual purpose of the transaction and had to give its assessment whether it was indeed concluded with a purpose of pushing out one of the parties out of the market, or at least would it, or was that the part of the deal that the other transaction participant exits or stops its activities in the relevant market. So the court ruled that the agreement is anti-competitive, and also in such cases the restitution claims are possible. So I think it's the biggest learning lesson here again, that the asset deal must be targeted at the actual intention to take over the operating assets without the anti-competitive intentions. So on this note, I have to now end my presentation. Thank you for bearing with me in the beginning with the technical errors, and in case of any questions, I'm happy to answer them.
Thanks, Marianne, for your very detailed overview and illustrative examples. And while the other speaker is preparing, let me ask you one question. Could you just list 2 or 3 points how a buyer could make some kind of preliminary quick self-check when assets may fall under the merger control enforcement? Any tips for that quick self-checkout?
So besides the obvious threshold thing, I think the main question that needs to be analyzed is, does this transaction actually result in structural changes in the market? And if these assets enable the generation of actual turnover. So we, as I just ended my presentation, this example of Tartu Mill, we have to again understand, or the parties had to understand what are the consequences of the transaction, and what is the actual the turnover that they have to include in their business decision. So when acquiring a company, or when acquiring like part or assets, the turnovers generated by the same assets have to be taken into account, not the possible win from the fact that the other party of the transaction is exiting the market or stopping their activities.
Thanks, Marianne. I believe we will continue the discussion in the end of this webinar. And now let me invite our Latvian colleague, Māra. Māra will look at the application of merger control rules in cooperation among undertakings and discuss the specifics of joint venture parties should consider. Māra?
Hi, everyone. Now I'm going to share the screen. Okay. So just to start, have you ever tried to play basketball alone? Probably if you have had, then you have noticed it's not much fun, right? There are also in business games that are better played together, and it's amazing how huge efficiencies may be achieved in case if market participants cooperate. So this cooperation in practice, of course, takes different forms. So just to start, few examples of cooperation, and to see that seemingly similar transactions, corporations are treated completely differently from the perspective of competition law. So the first example, classical joint venture approved by EU Commission recently between several cell phone operators in Europe, creating completely new privacy by design digital marketing technology platform intended actually to create a EU-based competitor to Google and these large worldwide players. Another example, in Estonia, there was a high-tech joint venture between Eesti Gas and Tallink, constructing new LNG bunkering vessel, pulling together the resources of marine experience and energy experience. But in this case, as a general rule, competition law does not really care about any activities between companies belonging to one undertaking, one group of companies. So this is not bound by the competition law. Another example in Latvia, consortia between Latvian and Belgian company building central passenger station in Riga. And this is again not a merger because it's made for one specific public contract award. So it's not full functioning joint venture. It's not. It doesn't have this long-lasting corporation element. So which legal rules are applied to joint ventures in the sense of merger control? In substance, it's merger regulation, EU or national. When the merger regulation is applied, then companies are kind of receiving actually legal certainty. I will talk about that later on as well. And at the same time, agreements regulation still applies to such corporation to all the elements falling outside of the joint venture, which is notified, or in case there's joint venture that doesn't have to be notified, it's still bound by the agreement rules. So jurisdiction is EU or national. The thresholds are important to find out whether or not this merger has to be notified. The EU Commission has sole competence in case the EU thresholds are met, and in that case, national rules are not applied anymore. As regards Latvia, in practice, there are several joint venture cases per year decided by Latvian Competition Authority. And it happens also in extraterritorial cases, which is something specific actually for joint ventures because many parties are involved normally. And there may be a case as was that companies which belong to the groups having turnovers in Latvia, Lithuania and Poland are establishing joint venture with the intention to operate only in Bulgaria in hotel business. And still, they have to notify this joint venture in Baltic states and in Poland. So when there's a merger, there are those few specific elements that have to be fulfilled. There should be a joint control, 2 or more persons or undertakings acquiring this control, and it should be a full functioning joint venture. So that means joint venture must perform on a lasting basis all the functions of autonomous economic entity. So what does it mean? In classical situation, completely classical example is when there is a joint control, is when parties, parents have equal shareholding and equal voting rights. So very classical example. However, be sure that this is only a very rare case, actually. In more cases, we see a specific structure of decision-making that actually leads to conclusion that there is a joint control. So it's almost never such simple case. So control means rights, contracts, or any other means which either separately or in combination or having regard to considerations of facts or law involved, confer this possibility of exercising decisive influence on the undertakings concerned. So it may be de facto or de jure, so all the elements have to be assessed. It almost never will be seen from the legal perspective very self-evidently. Decisive influence normally means the power to block actions which determine the strategic commercial behavior of this joint venture. And the essential feature here is the possibility of deadlock arising from 2 or more parents to veto proposed strategic decisions. So what effectively requires them to reach that unanimity in decision-making in determining the commercial policy of this joint venture. And again, another concept, strategic commercial decisions. It's again specific concept, and likely those will be the following: budget, business plan, unless it's very general, the appointment of senior management, investments, unless those investments are very like requirement for unanimity is very for very high investments, or this investment doesn't play a like significant role in the business operations of the joint venture. And joint control may be established based on different, each separately or mutually interrelated factors. So, such as equal voting rights, as I mentioned already, negative joint control, veto rights over strategic decisions, and that includes also minority shareholders acting together to veto certain decisions, and put options, the case where one shareholder can require another to buy its shares in a company. So in Latvia, we have this example of wrong understanding where there is joint control. In 2010, Ostas Flote was fined by Latvian Competition Council. The case was that minority shareholder brought this case to competition authority, claiming that there's joint control because minority shareholders' rights to vote were restricted by court order. So during that period, of this restriction, actually, it was found that two other major shareholders exercised joint influence. What are the cases where the acquisition of control can happen? So new control, that simplest case, acquisition from third parties, or creation of greenfield joint venture, or a creation of joint venture with the contribution of assets. But it can happen also when there are changes in the structure of control, a change from sole control to joint control, or other way around, from joint control to sole control. We have also an example in Latvia for that one, when Estonian company had joint control together with the Luxembourg company in Latvian company, and due to amendments in shareholders agreement, actually the sole control was acquired, and the company was late in notifying this merger, and notified only 2 months late after these amendments in shareholder agreement. So yeah, so it was fined by failing to notify merger. There may be also a change in form of increase in the number of shareholders exercising joint control. Also in such case, it should be notified. There may be replacement of existing shareholder already in jointly controlled undertaking. And specific cases where there is acquisition actually of sole control, if in the initial startup period there is joint control, but due to agreements between the parties, it leads that after this initial period, actually one of the parties will have sole control. It normally is treated as one merger of in form of sole control, even though there are several phases leading to that sole control. And non-full functioning joint venture may be due to widening business or other reasons, become actually a full functioning joint venture. And there has been a case also in Latvia for that. And what is important that the date of concentration, the date of merger is the date when decision leading to that full functioning has been adopted. So it's again important to know that this decision actually is the one which leads to merger, so not to be late with merger notification. And failure to notify change may become important in case if future transactions are being notified. We have seen this also in practice. Even though there might be changes in joint venture structure, decision making, and it's not seen anywhere outside of the joint venture, and it's not public, and it may be, the competition authority may not be aware of it. In future transactions, if they are notified, the competition, this may reveal to competition authority. So in that case, again, there is a risk of fines for not being notified the previous merger. When there is a full functioning joint venture, which is another criteria, if it is operating on a lasting basis, what means unlimited duration or for a sufficiently long period to bring about lasting change in the structure of the undertakings concerned. So again, like a legal concept that has to be interpreted with regard to the facts of the case. It's not the case in startup phase of the joint venture. It's not the case when joint venture is established to construct, for example, a plant for specific purpose. It's not the case when it's established for receiving this contract award in a case of public procurement. It is the it requires also that it fulfills all the functions of autonomic economic entity. And to interpret this, the key questions actually to be asked are the following. Does the joint venture have its own management dedicated to its day-to-day operations? Does it have access to sufficient resources to operate independently from the parents? In particular, those will be finance, assets, staff. Will it operate in its own right on the market, or is it essentially taking over one activity of the parents? For example, distribution or research development or production, actually serving, being established only for serving the parents. In that case, it will not be full functioning joint venture. Is there a predetermined duration of the joint venture, or it's unlimited? How heavily will joint venture be dependent on the parents as a supplier or purchaser of the inputs? And what proportion of the joint venture sales will be with the parents opposed to the third parties? So if it's more than 50%, it's a strong indicator that it's full functioning joint venture. And again, it may change over the time, so it needs monitoring, constant monitoring. There are specifics also in regards to calculation of the turnover. Only joint venture meeting thresholds on EU level or national level have to be notified, even though they are full functioning. And the turnover considered is the one of controlling parties, and if applicable of the groups, and the joint venture itself. And in case of joint venture, the turnover attributed to controlling entities in proportion to their shareholding. There is specific case if the joint venture itself acquires the target. So in that case, the turnover considered is of the joint venture and the target normally. But it can also happen that the turnover considered is of the parent of the joint venture and the target. And there has been a case also in EU level regarding this. The test applied is whether or not the parent companies are in fact the real players behind this transaction. So in case the joint venture is acquiring a target, then parent companies must carefully consider whether or not they will be regarded as real players behind this transaction. So in case they are real players, then the turnover of the parents will be considered. That may be a game changer and may lead to the obligation to notify. As regards substantial assessment of joint venture in general, it's similar to other mergers. It's assessment of business combination, but there are specifics like spillover effects in this case, because normally the parents of the joint venture keep their businesses, standalone businesses, and there are separate interests for them. Ancillary effects are also assessed, for example, non-compete obligations. Normally, the parents undertake not to compete with the activities of joint venture. And if those, it's assessed during the merger procedure if they are related to joint venture, but there may be ancillary effects or some obligations that are outside of the operations of the joint venture. So they will be bound by agreement rules again. It's subject to more detailed assessment if any of parent companies are active in a related or upstream or downstream markets, and of course problematic if in oligopolistic markets. So normally joint ventures, like mostly joint ventures, when assessed in substance, they lead to positive outcome in merger notifications. However, there are cases when they are prohibited. As in this example, when Commission prohibited the merger of several steel supply companies, where Commission found that in one market it will create dominant position, and in other markets there will be removal of this important competitive constraint. So finally, the key takeaways from this is that in case of joint ventures, the first step is the most important one, to identify at all whether there is a joint venture that is bound by merger rules. And it includes identification of the transaction as such, which transaction leads to concentration. It includes assessment of full functioning of the joint venture, proper calculation of the turnover involved, which may be a game changer, and getting analysis wrong can be costly in form of fines and potential voidness of the transaction afterwards, and better late than never doesn't really work here. So in case of joint ventures, there is like higher risk of being involved in situation where actually the merger has happened, in a gun jumping case, basically. Notified joint venture enjoys legal certainty regarding also the agreement related aspects of that joint venture. But in any case, if the business activities are widened and changed during the time of joint venture, and as regards the communication among the parties, still it must be carefully assessed also against the agreement rules in parallel. And any planned changes having an impact on the decision-making of this existing joint venture also needs constant monitoring, not to be late with notifying actually happened merger. So thank you very much. I am finishing, and will be happy to reply to any questions.
Thank you, Māra, for your insights. You really provided quite some tips and questions which should be considered when establishing a joint venture. And from your professional experience, what are the main current challenges in merger control enforcement for joint ventures compared to other type of transaction notification, if there are any, you could think?
Yeah, so first of all, as I already said, that the assessment of the joint venture, initial assessment, is, I think, more difficult. Of course, also in case of asset deal, it might become difficult to assess whether or not this is a merger. But from the legal perspective, it involves like large assessment in the initial stage. So the companies should dedicate time and resources for that prior establishing corporation in a form of joint venture. Second, during the notification procedure, more companies are normally involved. So, and they have separate business interests still, the standalone businesses. And the risks of collusion, like prohibited information exchanges, larger than in any other case of mergers, in any other type of merger. So Also, during the notification procedure, it takes more time to exchange the information, to exchange it properly, to get it from all the involved parties, to get acceptance, etc. And finally, when the joint venture is established, in other types of mergers, there is a safe zone. You have acquired the asset or a company, and that's it. You may operate without being in increased risk zone. But in case of joint venture, you need still continuously carry out this monitoring and be cautious with regard to operations and their compliance with the competition rules.
Thank you, Māra. I believe we will get back to these issues in the event, in the end of the event. And I also remind to our audience that you can put forward your questions in the chat box. And let's continue now with our colleague Jonas. And Jonas will look at the myths and some type of general understanding that Latvia, Lithuania, Estonia is kind of one market, considered like Baltic market. And keep a look whether it's true in merger control procedures. So Jonas, the floor is yours.
Good morning, everyone. Very excited to be here with you today. And I will share my thoughts on merger control review with increased focus specifically on major cross-border deals, which are subject to parallel reviews by all three Baltic authorities. So I will not talk about the rules, nitty-gritty details, and instead discuss or walk through end results and length of procedures. So those aspects which are the most important for people who are involved in transaction planning. I will start my intervention by explaining why this topic is important. And then I will highlight the trends that we see from recent practice, and later on I will illustrate those trends with a few examples. And I hope that Mindaugas will later on pick up on those examples and give his take from a more substantive view. So why this topic? Understanding if and how the authorities' review of competition effects differs in each country helps to better assess the perspective of getting the merger through. And secondly, it helps to plan alternatives to the initial transaction idea. So in other words, the better you understand how the transaction will be reviewed, any difficulties or nuances, local nuances you will face, the better you can plan in advance any need to make preparations for changes to the transaction structure or business structure. So as you may know, carve-outs and divestments are the popular solutions used by or accepted by the competition authorities to solve many problems that they will identify during merger control reviews. So why we focus on this specific Baltic angle? Sorry. So the transactions which are reviewed by all authorities usually handle very similar situations. So just basic common sense suggests that they should investigate similar concerns and arrive to similar conclusions. And here to add, the competition assessment is conducted by applying the same assessment criteria adopted by the European Commission. So it means that the same rules on assessing the mergers are used on EU level, the Baltic states, all other European countries, and even beyond. So this uniformity of rules actually connects with what was already discussed to some extent by Māra and Anne, that the substantive competition rules apply in all Baltics states without any significant or notable differences, except for, of course, what Marianne was alerting about a few examples. So on paper, there are no rules issued by any individual Baltic authority on the assessment criteria. So there are no such rule book like Lithuanian competition assessment rules or Estonian rules on how to review mergers between competitors. So, and a third point is that from market characteristics perspective, as Rita was alluding, we have a lot of similarities across the region. As you, it's very obvious. We are very similar to other tightly knit regions like Benelux and Scandinavia. Also, those regions and European Commission decisions often regarded as a single market. And so in the Baltics, we have very obvious similarities in size, demographics, market traditions, customs. We have same supermarket chains, same banks, many businesses with Baltic origin operate across all three countries in similar scope. We have single distribution centers and which cover all three countries. So when the same transaction undergoes parallel merger control reviews in different Baltic countries, it is of course very natural to expect same or similar outcomes. Well, however, sad news is that you cannot always expect uniformity in outcomes across all the Baltic countries. Well, sure, this goes against basic intuition. However, from today's viewpoint, you cannot expect to receive those three green lights in each case when the same transaction, characterized by very similar business profiles, similar competitive landscape, and similar market characteristics are reviewed by all authorities. And when I'm saying similar business profiles, similar competitive landscape, I am speaking from how the situation is often viewed by the businesses involved in the transactions, because they have this natural understanding of the environment in which they operate. So, of course, not all is bad. There are, of course, at least several cross-border transactions each year that go without any problems and receive all clearances in a fast manner. So another key trend that we see is that the length of procedures is almost always drastically different, and there is no united review timetable in the Baltics. Formally, they are similar, but in practice, all authorities conduct their reviews independently, and maybe Mindaugas will have another opinion, but frankly speaking, we hardly see any coordination between the authorities when it comes to those larger transactions. So just to explain why the length of procedures is important, so long transaction timeline and intrinsic uncertainty surrounding a merger from transaction side negatively affects and increases the risk that any of the party would walk away from the deal, and from commercial and operational side, we see that that lengthy proceedings negatively affect relationships with employees, clients, and suppliers. So now let's turn to a few examples that illustrate these trends. So one of the acquisition of Baltic Mill by Dobelis Zirnavnieks. Both companies are flour and pasta producers, and they also produce other food goods. Is a very illustrative case. After almost a 2-year merger review process, the Lithuanian competition authority blocked the transaction, whereas the Estonian and Latvian competition authorities permitted the transaction by granting their clearances well, several months earlier. And in case of Latvian competition authority, they cleared the transaction even a half year earlier. And as you see, it was one of those rare instances when the acquirer was very unhappy with the end result and was very vocal and was brave enough to go to the media and voice his opinion, because it's usually not often that the parties go to the media and make their views public. And importantly, the Latvian and Estonian competition authorities grounded their decisions on a failing firm defense. So, in other words, the authorities saw that one of the production facilities located in Latvia was undergoing serious financial difficulties, and it was about to go bust. So they reasoned that there is no basically difference if we permit or we don't permit this transaction, that this facility may go out of the market. And well, the Lithuanian Competition Authority did not consider this topic, but to some extent it may be well explained by the fact that that production facility was routing its supplies to Estonia and Latvia, and to lesser extent to Lithuania. But well, here it is a good example where the intensity of review and length of proceedings differ, and we often see that the Latvian Competition Authority is usually the first to adopt its decision. It's of course not a rule, but like in all cases, but this trend keeps repeating itself even in minor transactions. Another notable example was a merger between two major Baltic agricultural players, and we also see more or less the same picture regarding the length of proceedings. But as you see, all clearances were received, and the transaction didn't face any notable hurdles. Another recent fresh example is another major transaction, more concerning Latvia and Estonia, and we see that only a few months after the definitive agreements were signed, the Latvian authority cleared the transaction. And from last time I checked, Estonian competition authority is still reviewing that transaction. So if I'm mistaken, my colleagues will clarify. Another notable example is a merger between two major cinema chains in the Baltics. And in all countries, the situation was very similar. That these are the main players in the cinema viewing industry. And here we see that the Latvian authority clear the transaction with a carve-out, a combination of carve-out and divestment, whereas in other countries the review faced a lot of challenges, and the parties decided to abandon the deal, at least to the extent of those particular jurisdictions. Here it is a small slide trying to see to show how we see the process, and that we have more formal steps and some steps which are which cannot be forecasted on how long those steps will take. And even though this slide says that there is a stop the clock mechanism where the formal well, review timelines can be paused by the authorities, the same actually is present to some extent in other countries, but we don't see such mechanism to be used. So what factors determine those different outcomes and different length of procedures? We thought very hard and long about it, and the explanation is just to a major extent it's more about people who are working in those authorities, and not always the outcomes are explained only by the mundane economics and differences between the market characteristics. We note that even in staff there are some different differences. For example, in Latvian Competition Authority, we know there are more economists and people with no-law background, like financial analysts. So maybe they're less inclined to do what lawyers love, is to be risk averse and check all the boxes and make sure that everything is safe. So this is could be an explanation why there are major differences between our countries. So yes, soft factors could be one of the important explanations why we some deals go on and on in the reviews, and some deals are reviewed faster. So that's it from my side. Thank you very much for your attention.
Thank you, Jonas, for deconstructing that myth of one Baltic market. And Jonas, you have illustrated how different approaches of national competition authorities may have a significant impact on transaction lengths, and so the possibility to close the transaction, close the deal. And would you have any very quick advice to a buyer dealing with a cross-Baltic merger, trying to control, at least to a certain extent, the outcome of merger review?
So my advice would be to not get only advice from a competition lawyer, but to get advice from all Baltic competition lawyers from all Baltic countries, and if they indicate that we have to involve competition economists. So it's a very serious recommendation that should be taken seriously, and economists should be involved even in this pre-filing phase, and even in transaction planning phase. So whenever investment bankers are considering the transaction or advising potential clients, they should also get in contact and think about the perspectives of getting the clearances as soon as possible.
Thank you, Jonas, for bringing that very kind of positive and not always in practice, very applicable advice of getting opinions in all countries and getting specialists necessary in the very beginning of the processes. And I would like now to invite our last guest speaker, Mindaugas Cerpickis. Mindaugas is a managing economist in Copenhagen Economics. And as you know, a merger control process is based on legal rules. However, merger review and its outcome very often, especially nowadays, depends. And there's a massive question of economics, data, and economic assessment. And usually, as Jonas already indicated, it's a massive necessity for all lawyers and economists to work together. And therefore, today we have an opinion and approach of economist. And Mindaugas and his institution he represents, they work with mergers in the Baltic, across Baltic states, also with other EU member state-based mergers. So he has quite some experience and quite some professional ability to compare the processes, to compare the aspects which different competition authorities take into consideration. And we are very happy to have him here. And we hope that he, in his very brief 5-7 minute presentation, he will share his insights on public cases and aspects Jonas, Mari, and Anne were discussing.
Thank you, Rita, for having me here. And as the only competition economist in this panel today, I really appreciate, Jonas, your comment about the need to bring competition economists to cases. And also I can confirm, having worked on merger cases across all the 3 Baltic states, I can confirm the insight that people working at competition authority are not the same in all 3 countries. But maybe let me, so Jonas mentioned some differences across the 3 countries. Maybe let me start my intervention here with maybe similarities across all 3, and especially from the economic perspective. So all 3 competition authorities have teams of economists, and well, they decide in each case whether they should bring economic experts on individual cases or not. And this is where you can have also some different results, because it's not always the case that economists are brought on the same case across all 3 countries. But all the economists in competition authorities in the Baltics and beyond Baltics, they focus on one thing. It's consumer welfare. So not the producer welfare, which I suppose is quite obvious in all mergers, that companies see some value in merging, right? So that is almost as a given. But the key concern for competition authorities and economists working there is how the merger will affect the market power of the companies that are merging, and basically the key concern, and usually, is whether or not the merged company will be able to increase prices, or reduce quality, or reduce investments in the future. But usually it's about prices, how this will be affected. And historically, the rule of thumb has always been that the higher the market share of the companies merging, and especially the increment, so to what extent the market share will change after the merger, the higher the market share, basically, the bigger the risk. In these kind of cases, as a rule, economic analysis is being brought into the case. So when you have smaller mergers where market shares are low, well, we are not involved that much, I must say. Maybe sometimes economists are also involved in smaller cases, but at least our experience in the Baltics was usually with large and complex mergers with high market shares. And then there's, for an economist, there is always a question. So, okay, so can we trust market shares, and can there really be consumer harm when you have two companies with high market shares? And actually, the answer is not that simple. There could be situations where two companies, even with high market shares, are not really able to increase their prices, basically harm consumers in any other way. And these are really interesting cases for the economists, but this is where sometimes these merger investigations really drag out. The sooner this question is being addressed, like ideally even before notification, the better the outcome in terms of speed and the overall experience for everyone, not only the merging parties, but also for the competition authority. And when we speak to the competition authority and the economist team there, they always highlight the importance of bringing strong and coherent economic evidence as soon as possible in the case. That really helps. And I cannot overstate this. It is really helpful for the parties to think about the economic impact of their merger before notifying it, and then accordingly look at the whole notification. What do you say about the market definition and so on, to see whether it is actually coherent? Because quite often there is this inertia and maybe some kind of presumptions in companies about things. So what is the market? What is not the market? And if you don't question it, then you can easily end up with a notification which later, when it's being scrutinized, then you see that there is some inconsistency. But then you're trying to renovate a building after it's being built. It's always easier to build from scratch in the right way, the way you want. Yes, so that's just a tip about the procedure. But maybe just a few words about when I said about the two companies with high market shares. Maybe it doesn't sound obvious why a situation with two companies with high market shares, why they may not be able to increase prices. And from the economic perspective, well, first of all, market shares don't tell much if the market definition is wrong. And from the economic perspective, there are so many ways how you can define a market. Just taking, an example of, let's say, like chicken, Jonas mentioned, of course, when you think about chicken, it's quite clear. Like, it seems like an easy thing to define a market. But what about pork? When you go to the supermarket, if you see the price of chicken is really high and pork nearby is cheap, maybe some customers would find it possible to substitute. Should it be part of the same market or not? I don't know. What about free-range chicken and just regular chicken? Should they be part of the same market or not? All these, and then you end up with quite many possible combinations, which at the end, and which influence the market share of the parties. And especially when you have thresholds, with one combination you can get above the threshold, with another combination you can below the threshold. So it gets quite complicated. Then let's say the market is defined correctly and the market share is high. Let's say, in theory, it's correct. Well, when companies compete on prices and they have no capacity constraints, in that situation, even one competitor after the merger could be sufficient to maintain prices low. When there's no capacity constraint, it will always make sense for that remaining competitor to undercut the pricing of the merged company, even if they have a high market share. So in that situation, they would not be able to increase price. Also, when you have tendering markets, so when companies are competing for the market, you can have situations where there is a really high market share by a company, but it's only a result of intense competition. Because there was a tender where everyone submitted their bids, it was super intense competition. It will result in high market share, but only until the next tender. And the next tender, someone else can win. So you will always have quite a high concentration from that perspective, but prices will be always constrained by that tender. And this is where the buyers can actually use their bargaining power to keep prices low. So that is also a very important factor. Another important factor, especially for the Baltic countries, which are relatively small and open economies, really open for trade from neighboring countries, market entry is an important factor. So even when you have high market shares based on like domestic market definition, it is important to consider whether it will be possible for competitors, especially from nearby countries, to enter in case the merged company will try to increase their prices. And if you can find any evidence for that, that should be considered in the assessments. And lastly, the synergies. So as I mentioned, the point is consumer harm. And so it's not about whether or not the company will be able to increase their profit margin. That's not the problem. There might be good reasons for companies after merger to increase their profit margins because of synergies. And sometimes this can actually lead to a situation where it makes it not profitable for the merged company to increase prices because they just reduce their cost in a way that the current price level is optimal for them, even though they have market power, even though they gain market power. And in theory, all mergers increase market power. It just, in theory, that's always the case. But it is a question of really consumer harm and whether they have any incentive and ability to create this harm. And that's why we do see a tendency also in the Baltic countries, but especially in Western Europe and also in cases analyzed by European Commission, to put less and less weight on market shares and especially market definition, because as I mentioned, it can be a really long exercise and without too much value, because if the end result, if the ultimate question is about harm, why not just focusing on that? And that is the tendency we see in Western countries for sure.
Thank you, Mindaugas. I would like to remind the audience that they can put the questions in the chat box, and also I invite our speakers to use their position and maybe raise questions for each other. But in the meanwhile, I would really like to jump straight into some aspects and insights Mindaugas shared. And reflecting to the cases Jonas discussed across all the Baltic countries, and we had seen those larger companies with large market shares trying to get the merger clearance, and we had different outcomes in different Baltic states. And I think for market, it's really a signal, so what to expect next, how to have that control of merger review process, at least to a certain extent, and to be a bit more sure what to expect from one member state or another one. And just not getting into too much detail about particular cases, just thinking about large companies with large market shares, how they could put themselves through the process of notification, as you said, showing that there will be no consumer harm, and what aspects that should be put, and are there any advices you could think of?
Well, we were involved in these large cases, so I cannot comment details of individual cases, but it shows the principle that each case is assessed on its own merits. You can the companies thinking about merging should not expect that the decisions can be just copy pasted from one to another, even though there might be some similarities in terms of like industries or market structure. Each case is assessed on its own merits and on the evidence being brought forward by the parties, and also very importantly to realize by third parties. Third parties are super active in these, especially large cases. I don't know about the smaller ones, maybe you have a better view, but in those large cases, third parties who would be affected in one way or another by the merger are very active, bringing their evidence. And as an economic expert, I can only wish to have a bit more transparency on what arguments and what data is being brought forward by the third parties. So yeah, I think that's something I can only wish for.
Yeah, I think we all would like some more transparency in mutual control processes, and quite often from colleagues from other member states, when they see decisions of 2 pages on merger notification, they are a little bit shocked of not having particular definitions put forward for public. But this is another issue which we cannot solve, and we probably can talk only about things which depend on us. And referring to your focus on market shares and actually doubting whether it is the very right approach, I was wondering maybe you could just a little bit clarify and confirm whether it is a tendency from Baltic authorities to focus a bit more or too much on market shares when getting to their final decision.
Okay, just to make my statement a bit more balanced. So market shares are important. I'm not saying they're not important at all, but in all the cases, they should not be sufficient, especially for prohibition of a merger, because, as I mentioned, there are these many other factors which can have a decisive role, basically, in terms of how the merger will affect the market. There are cases when market shares indicate really the market power and so on, and it might be, but you will only know it after you have assessed these other factors.
Do you see similar tendencies and focus on market shares compared the Baltic states to other EU member states authorities? Is it more or less the same tendency, focusing on the market shares, or there is a little bit more, to say, balanced approach?
I think all the countries share the history of putting quite a lot of emphasis on market shares, but countries are moving at different speeds towards more effect-based approach, about which I was talking about. To be fair for the Baltic competition authorities, I think they are also really focusing on effects as well, but it is really, it all comes down to the question how much evidence was has been collected during the investigation period about the effects, and everyone have limitations. The parties have limitations in terms of how much they want to invest in bringing that evidence forward, as well as the competition authority. They need to prioritize multiple cases at the same time. So it is really, I wouldn't say that there is like fundamental disagreement that effects are important. I think no one disagrees with that. It is more about the ability to actually investigate it.
And talking about the fact-based approach and that evidence, I know that, as you mentioned, economists usually are involved in only larger cases, which are already complex and massive. And talking about evidence, do you see any kind of, I don't know, mistakes or very common errors the same lawyers, for example, or companies do when trying to put forward the notification and constructing the transaction?
Yeah, I could just mention one thing. The competition economics is a quite different thing than the business economics. And having studied both, I can really tell the difference. I used to be a management consultant in the past. What I notice when competition economists are not involved in cases, in the beginning, for instance, and are just involved later, the case rests on many assumptions coming from the business economics, which may be quite inconsistent with the logic of competition economics. So I think, and that's largely, something that the merging parties are responsible for, I would say, yeah, I think I have nothing to add. I think that's the main.
It's talking about that, as you made a diversification between the business economics and competition economics, would we quite often hear from our clients that they usually are really considering and expecting from their business logic perspective that other markets and competition from neighboring countries like Poland, Scandinavian countries, that will be taken into consideration when reviewing the merger. But as we see, sometimes it is, sometimes it's not. So if you could share your insights on that competitive pressure coming from neighboring countries, especially in Baltic markets, how much it is a factor in economic assessment, and how much you see and feel that competition authorities are actually taking that coming pressure from, let's say, Poland and Scandinavian countries into consideration.
I think on a principle level, it is an important factor and recognized by everyone, at least in the cases I was involved. It is more question on case-by-case basis, how much analysis of that factor has been conducted by the authorities and by the parties themselves. And this pressure from neighboring countries, it is relevant in some markets. It may not be relevant in other markets. It really depends on the case at hand. But we as economists, we have tools to help the parties and the competition authority at the end to assess this factor. And it even when actually just from the economic perspective, you can have influence from producers, let's say in Poland, right next to Lithuania, even when they are not really de facto selling at the moment. I think from the business perspective, this sounds as common sense. Of course, you can be affected if you have the threat. Just the threat of a competitor is sufficient for you. But it's not sufficient just to state that. For the competition authority, they need a little more solid evidence, which would support this hypothesis.
Thank you, Mindaugas. I think I have a question for maybe all of us. And Jonas made that implication that differences in outcomes from time to time come because of differences of people. And we know that in Estonia and Lithuania, we're having new, if you can say, arrivals of new heads. And I was wondering, maybe Marianne, Mindaugas, and Māra Jonas could just share what do they think, whether those new arrivals have any kind of particular changes in merger control enforcement. Mindaugas, we can start with you. You could just share some experience from changing of heads in other member states, and you face that, whether economic theory changes what you use in notifications.
Well, very shortly, actually, I don't know. I don't think any of them are economists, so it's difficult for me to judge. I guess I'm just looking forward to see. I hope the focus on economics, which I have seen over the last years, will stay. But I don't know exactly what will be the impact of this change.
Marianne, what about your insights?
Yes, thanks. Well, currently we have not noticed like any significant impacts or any like big developments. We're just happy that the productive cooperation with different market participants is still ongoing. And we just hope for the continuing of this positive outcome and positive cooperation.
Jonas, any insights about our new coming head of competition council in I think very few weeks?
So the new head has been in the past a member of the council, and she's a long-standing part of the competition authority, in the sense that she contributed to a lot of traditions, and she was around for long, so no observed changes. Rita, maybe you have a different take on this.
Well, I noticed that a change in management is always a change in management. Probably it won't change economic theories, might change some priorities and certain aspects of how the procedures are done. But of course, we all expect close cooperation, as Marianne is saying, and that also a close communication and transparency, as Mindaugas mentioned, that at least he is missing on some point. But I would really like to thank all of you for your very insightful, detailed presentations and discussion. And as we see, this topic is really very wide, and there are many things to be considered, both by companies and emerging parties and lawyers and economists together. And thanks a lot to everyone for your attention, and we're really are here for your assistance if you need any kind of help regarding complex merger matters. And I really hope that we will see you in the very near future. So bye-bye and have a good afternoon.